Welcome back. An octogenarian who is one of the oldest practicing lawyers in the country today, Patunji Gomez, has also weighed in on this issue of lawyers being appointed as justices of the appellate courts. He is totally against the idea.
I am sure that the majority of the lawyers will not appreciate the movement by which the procedure is being put into effect. Number one, the position does not follow due process. And it is very important for a big change like that all lawyers should be consulted. They were not consulted. The question is, what is the hurry? Why must they give them 3 days? And what procedure did they follow? It is inimical to the judiciary, it is inimical to the profession. Besides, it creates an unfair trading because, let's face it, they're not going to bring a junior lawyer over a son to be Supreme Court. That's unfair trading. Secondly, the Court of Appeal judges who have been there for years are being portrayed as unfit for the post of the Supreme Court judge. A man who spent High Court, Court of Appeal, now suddenly you say it's not fit, you go and bring a lawyer. It is demeaning. It is a sign of condemnation to the Court of Appeal that they are not fit. And that is very, very bad. It is bad because people won't respect them anymore. It is bad because the judges of the High Court are being told that these SAN are superior to them, which is not true. It gives a tremendous impact of fear on the judges of the High Court.
I reminded Pa Gomez that 2 of the finest judges in the history of the country today were actually appointed from the bar and suggested that perhaps this may have some merits, but the senior lawyer completely disagreed.
Dr. Elias and Namani, 2, those are exceptions. No. It's exception because we have judges since when? Even since, let's take it from independence, when Justice Ademola was there. It's over 60 years. We have 2. That's exception, not the rule. They want to make it the rule now. And like I said when I was opposing this, our people will start to extend it. It will be no longer a judicial matter. We will be appointing political judges. My brother is this. My Attorney General must be Supreme Court judge. We won't have justice in the end. I said this before when I was fighting the Sun. Now see what the Sun have done. Oh, they said we learn. You all know now. I don't have to tell you. They all show us how to bribe. That is not good. When I came to practice 56 years ago, you are proud to be a lawyer. Now you are not proud to be a lawyer. How can a son bribe a judge? That is the same thing this will end up. If you are in a position where you are from the High Court, you go to the Court of Appeal, now you are a senior Court of Appeal judge. Then instead of going to the Supreme Court, you go and pick a practicing lawyer. What do you feel? Is that justice? Is there any reason to compare the judge with his SAN? What is the comparison? Let them suspend it. The lawyers are not fully consulted. Let us suspend it immediately before we kill the judiciary. Because if we don't, it will end up like Tom, Dick, and Harry becoming a Supreme Court judge. We must stop it. And that's why we are calling on the CJN and NJC to stop this ridiculous appointment. I know there's a provision in the Constitution, but it is for exception. If in over 60 years, we only use 2, now they want to, does it not show that they need perfect, full consultation to hear the opinions of the Supreme Court judges, the Court of Appeal judges, the High Court judges, and the lawyers and their branches. This must be done. Otherwise, the judiciary will be finished. I call on the people concerned. They can call the stakeholders meeting so we can discuss this properly. So my call now is that they should suspend this ignominious, ridiculous appointment to the Supreme Court.
The Octogenarian has also said that the majority of the members of the Lagos branch of the Nigerian Bar Association are opposed to the appointments.
And just before we go, let's bring you a recap of some of the top legal stories we're keeping our eyes on.
We begin with the report that the Federal High Court sitting in Lagos has ordered the final forfeiture of the sum of $153 million linked to former Petroleum Minister Mrs. Diezani Alison Madueke. The monies in question were allegedly siphoned from the Nigerian National Petroleum Corporation and stashed in 3 banks in the country. Mrs. Alison Madueke has, however, denied that the money belongs to her. Neither her nor the NNPC came forward to lay claims to the money. Justice Muslim Hassan in the judgment said the EFCC had successfully proved that the monies were proceeds of an illegal activity. The court also rejected the move by a banker challenging the final forfeiture of about $40 million out of the money. The EFCC, on its part, hinted that it will make moves to secure all the parties from whom these monies were forfeited so that they can face prosecution.
By this judgment, what we have achieved is that without going through prosecution, property that is found to have been secured or obtained by fraud can be forfeited to federal government of Nigeria before you even commence prosecution. And that is the beauty of Section 17 of the Advance Fraud that we have predicated our application on. So we are so happy with the judgment of today.
Staying at the Federal High Court in Lagos, Justice Mohammed Idris has fixed the 1st of March for the commencement of trial of a former governor of Oyo State, Chief Rashidi Ladoja, alongside one of his aides, Wahid Akombi, over an alleged 4.7 billion naira fraud. The court fixed the date after counsel to the Economic and Financial Crimes Commission, the EFCC, Oluwafemi Olabisi, urged the court for an adjournment to enable him supply to the defense team the names of witnesses that will be testifying in the matter. Ladoja and Akombi were arraigned before the court by the EFCC on an amended 8-count charge of money laundering and unlawful conversion of funds belonging to the Oyo State government. Mr. Ladoja and his aide have, however, pleaded not guilty to the charges. The same judge has fixed the 6th of March to hear a fundamental rights enforcement suit filed by a former First Lady, Mrs. Patience Jonathan, seeking to unfreeze multiple accounts containing about $15.5 million. The EFCC told the court that the account in which the money was kept was allegedly used to launder funds by 4 companies traced to a former presidential aide, Emmanuel Owe-Dudafa. The court then ordered that the accounts be frozen. In proof of the EFCC's position, the identified directors of the companies had pleaded guilty to an offense of conspiracy and money laundering in a criminal trial before another judge of the Federal High Court, Justice Babs Keumi. In the present case, however, presiding Justice Mohammed Idris has had to adjourn the matter after the request by some of the lawyers representing the companies for more time to study the case. And we round off with the report that the Supreme Court has fixed May 12th for judgment in an appeal filed by a People's Democratic Party governorship aspirant, Mr. Samson Oga, in the Abia State governorship election of 2015. The Apex Court fixed a date after hearing submissions from parties in the suit. Oga, who contested the primary election with Governor Okezie Ikpeazu on the platform of the PDP, wants the Apex Court to set aside the judgment of the Appellate Court, which upheld the nomination and subsequent election of Governor Ikpeazu on the ground that he supplied false tax documents.
And that's the program for today. Please send in any questions or comments about the program and indeed any area of the law. You can watch this episode again or even past ones on our YouTube channel. I'm Shola Shieli. Thank you for watching.